essential to file the patent application, and you can make the patent for that if it's technology. If you're claiming new design, you can go for the design. If you're writing books or novel, you can go for the copyright. So depend upon what kind of creativity, what kind of idea you are able to develop, you can go for that to protect and getting money out of that. Because IP is an asset like any other form of property. Now let us see how this idea arises. When you're in the classroom with your students, or professors with the students in the laboratory, or everyone is sitting in the lab discussing on a particular topic, or they're doing the research. During that, you may get solution to technical problem. Now, I am sitting alone in my home, in the balcony. I am thinking to write the book on the war between US and Iran. So idea to write the all details about the war is arising from mind. So it's an intellectual property. You can go for the copyright because if you're creating new book for that, or you are writing new poem, or you're developing some technology. For example, Nagpur is too hot. I can say whole Vidarbha is also too hot. Even Telangana is too hot. Even Marathwada is also too hot. So we know basic problem. If hot, you are all traveling by car, no problem at all. What about the people who are walking or going on the bike? So they are feeling too hot. So this is a prior public domain in any between and us. So how you give the solution for this? Somebody says you can use the umbrella. It is already known in the prior art, known in the literature survey. Somebody said it's too hot, attach small fan to that. Again, that is known in the prior public domain. So what could be the solution? These are the mere jugaad of yourself.
Sir, you are mute again.
सर म्यूट हो गया सर, सूर्यवंशी सर म्यूट हो गया. Sir, can you please unmute yourself, Suryavanshi sir?
Now it's okay?
हाँ.
Audible?
जी
Yeah.
जी जी.
Slides are visible?
Yes sir.
Yeah. So I was telling about the problem solution approach. If too hot, so somebody is saying umbrella, somebody is saying fan. Is it solution to technical problem? Yes or no? You can answer in the chat box. No, it's mere जुगाड़ to solve your problem. ये आपका जुगाड़ है कि आप problem solve कर रहे, but it's not in solution technical problem. Therefore, one of the engineering college from Andhra Pradesh developed cooling helmet. What is this? New solution to a technical problem. Please don't talk. Those who are not interested, they can go away. Those who are not interested, they can quit. I don't want to get disturbed in my class.
iPhone mute कीजिए. iPhone mute कीजिए.
You are the co-host arranging people, you can mute them. Dear all intellectuals, those who are not interested, please mute them. Since 1 week we are trying to what to teach you and you are all making us disturb. It's not good. Yes, thank you. So I was telling about the problem solution approach. So there was a problem, you are giving solution in the form of new idea. What is this invention, or we can say technology? So the idea, it is essential for the IPR. How your topic is relating to, see how I'm relating. Your idea is essential means to file the patent, because you are developing technology. It's in your idea. It's going toward the patent. You are getting technology, and by selling that helmet, you are getting money out of that. Therefore, IP is an asset again. You are getting something like that. So your topic is also same way. So IP is an asset like any other form of property. Now let us see one example. See, somebody has brought smart shoes for the blind. Why can't Bata? Why can't Puma, Adidas? There are how many companies are there involved in the production of shoes or manufacture of that, but no one thought. Why? There was a problem for the people who are blind. They cannot walk easily. Lakdishili, how they'll walk very slowly by keeping stick in front of them. Time consuming, hectic. To solve that problem, somebody has invented this. So, problem solution approach. It was there, but again, somebody has brought smart cane for the blind people. What is this? Improvement of technology. Smart cane indicates how much water in front of you on the road while walking, how much mud in front of you while walking. Again, whether signal is red or green, it indicates. It means you have to walk or not indicates. With how much useful smart cane for the blind people. Again, invention, technology, idea or creativity of your mind, you can go further. Again, commercialization. So अनदर एक्झाम्पल फ्रॉम युअर नागपूर. आपण काय म्हणतो, मोहाचे फुलं म्हणले काय म्हणतात, दारू बनवतात. ओनली फॉर द लिकर. बट one of the professor from your Nagpur, Dr. PC, has developed cold drink formulation out of that. What is this? New idea. And people like the taste of that. Again, invention or technology. So recent examples are many in the renewable energy sources, space technology, smart agriculture devices have got, UPI's got with phone pay methods. It's in software, you can go for the copyright. If technology, you can go for the patent. So depend upon what kind of you are developing technology, you are all that. Drones to spray the pesticides. What is this? Invention or technology. These are the simple basic inventions. Now, let us see what is the background of intellectual property. प्रॉपर्टी कहते आपके मन में आ जाता मेरे पास घर है, गाड़ी है, even land in my native, so I'm very rich enough. But there is another kind of intellectual property I cannot touch. That is an creations of my mind. That's called intellectual property. Or if you are creating your mind, that's called intellectual property. In that, we are having patents, designs, trademark, GI, copyright, trade secret, even all the. Sir, your session is I will join at 11 o'clock because I'm with another session. Okay, I'm with another session. Okay, I'll join sharply at 11. So these are the different kind of intellectual property. Let us see one by one. Before that, I told you IP means product of mind, but how to define that? Intangible creations of whom? Your mind, human mind. You are the intelligent animal in the animal kingdom, having power of thinking. Therefore, you are taking lot of challenges. You have invented airplane. You have invented vaccines. What not we are doing? Because we are able to do that. We have to accept the challenges that are called as an intellectual property and asset like any other form of property. Again, IP is called as an exclusive right. For example, somebody is filing patent from your college. So the right is with that person, not with their spouse, children, or parents. Only he can exercise the power of that. Therefore, we can say IP is also an negative right because other person in the family cannot exercise the power of that. Again, it's an territorial right. Once you are applying for the patent in the government of India, your right is only in the country of India. You cannot claim your right in USA, Japan, Germany, or any other country where you are do a business. For example, I'm filing herbal medicine cancer. It is not in the even in the throughout the world. Therefore, I can file India, even I can file throughout the country, throughout the world, because even not found. So how to file in the throughout the country? By means of two way. One is called PCT, Patent Cooperation Treaty. Another is called Convention Application as per section 135 of the Patent Act. So by means of two route, you can go to file your application even in the foreign countries. Again, IP is called as an licensable right. For example, Pfizer vaccines was developed, corona vaccine developed by which company? Pfizer. But they have assigned the right to Serum Institute of Pune for more production. Why? IP is licensable. For example, Hyundai companies develop some technology. They can assign the right to Tata Motors, Mahindra because they are having same business and they can give the right to each other depend upon the royalty or agreement whatever they are doing between both the companies. Now, what is patent? आपने देखा होगा मराठी मूवी दे धक्का मकरंद अनासपुरी is the actor in that. They have taught what is patent. Exclusive, monopoly privilege or right granted by the government of India, or who can say government to the patentee. Who is patent here? The person who is applying for the patent was the applicant at the time of filing. So, for example, you are applying for the patent today as an applicant, but after 22 months or 24 months, you are getting grant for that. So, you are called as a patentee for that. So, you are getting 20 years right from the date of filing or priority. When you are disclosing everything clearly, then only you are getting the right. What is that fully particular now? For example, we take today you came to the colleges or somebody attending from the home or by means of any means. So you might have taken the head bath. So everyone is using nowadays different kind of shampoos to take your head bath. Somebody Vatika, Sunslick, Doe, Wow, Mamaearth, Vedic, many shampoos in the market. But I am being a botany fellow. I am developing improved herbal shampoo composition comprising tulsi, ginger, vinca and other medicinal plants with the other expense for treatment of dandruff. What is this? Shampoo is many, but I'm developing my improved shampoo. My content is different. I have to disclose from which location I'm taking the medicinal plants. NBA permission, what part, what percentage, experimental details, efficacy, clinical data, all you are supposed to give, then that is called fully particularly. If you are not giving, you are getting objection from the government of India and you simply delaying getting the patent. Therefore, write in detail at the time of filing, that is called fully particular described. It is a requirement of section 10(4) of the Patent Act. And your right is territorial right, not worldwide. Now, all the BSc fellows are doing project, MSc fellows are doing project, and PhD research fellows are doing research in their own topic. While choosing topic for the PhD and research, what your guide says or your professor says, please bring three, I'll finalize one. Is this the way to select your project? No, not at all. You should know what is prior public domain problem in your own field. If you're physics, chemistry, biotech, micro, engineering, mechanical, civil, whatever problem, you should know what is prior problem in your field. Try to solve that problem by means of novel way, inventive way. If solution is good, novel, you can go for the patents. Because discovery is not patentable at all. Finding or experiment something which is already there in the nature is a discovery and it does not have technical effect. For example, I am the student of microbiology doing project in the MSc. I have taken topic as an isolation of microorganism from effluents of Serum Institute of Pune company. So my topic is to isolate microorganism. For that, I'm going to the Pune, collecting sample. Again, back to RTM University and starting my practical to do an process of isolation of microorganism. If my process parameters like pH, temperature, media of isolations are novel, are new, I can get patent for that. But I cannot get patent for the discovery because I have isolated microorganism from the nature effluents. I know that effluents have some microbes, so it's a discovery. I cannot get patent for that. But being the student of microbiology and biotechnology, I'm having knowledge of that. I'm developing genetically modified microorganism as an oilating bacteria, pH resistant bacteria, heat resistant bacteria, or any means. So genetically modified microorganism, I can get patent for that. So discovery is not patentable. Then what is patentable? How your idea should be. Let us see what is invention. All the inventions are patentable if they should not attract section 3 and 4 of the Patent Act. I cannot go in detail with section 3 and 4, but what is invention, I can tell you. Invention means new product or process. ATM machine is a product, it was not there earlier. CT scan machine is a product, it was not there earlier. Mamaearth shampoo was not there earlier. Only Chick, Vatika was there. Now we got that also. So it's a product. Process of making shampoo, process of making medicine is a process. So your idea should be product or process. Useful to all. Something novel. You know what is novel. While publishing your paper in the international journal, what you do? You check whether your research article, what you written in the public domain or not. If not, then you go for the public. Same way, if it is novel, non-obvious, and should not be in the public knowledge, then you can go for the patent. And it should not attract again Section 3 and 4 of the Patent Act. So you should check whether your research topic or project topic is qualifying the definition of this or not. If it is qualifying, then you can go for the patent filing. For example, simple device. We take our pet to walk, but our mentality is that my house should not get contaminated, let on the road or other side of that. So for that also, somebody has brought the device dog waste catch and holder. So it's very instrument to catch. Again, you can read that after that by putting the Google detail how he has invented. Very simple device. It's an mechanical device. How we catch the fishes? Throwing the net in the pond, river, lake, or ocean. But now somebody has invented enhanced fish attractor device. Again, invention or technology. See, these are the basic inventions. यदि थॉमस अल्वा एडिशन ये नहीं ले आते तो अभी तक हम लोग साईं बाबा के दिए लगाए बैठे हुए रहते. Somebody has invented that. So the person, you may be doctorate, awarded many PhDs under you, but you are not inventor until unless your patent on your name. So these are the examples of inventors. You know all who has invented this. Can anyone tell me this device was in the in the domain since 1876, even though somebody thought to give the mobile phone? What was necessary? By using this telephone, when British were ruling our country, they stopped by using this telephone. But our scientists thought to give the mobile phone. Why? Yes, dear participant, you can chat in the chat box if you are able to give the any ideas. Why somebody has invented a mobile? Because this is used to talk even foreign country, even India, even though, why? Any idea? Because this device is having some disadvantage that I cannot change this device from my cabin to my dean's cabin or my principal sir cabin. It is connected in my cabin, so everyone has to come to my cabin to talk. Again, if I want to dial 10 times घुमाना पड़ता है, very hectic and time consuming. You might have seen the old Hindi movie, Marathi movie. To solve that problem, we got a table phone. Now what we are using? I can dial easily 1, 2, 3, 4. But again, I cannot change from my cabin to my dean's cabin or my principal sir cabin. Therefore, we got cordless phone, which was long. We can take in the hall, kitchen, drawing room, or nearby area in and around me. But I cannot take in the meeting, nor in the car, nor in the plane, nor in the train. To solve that problem, we got the mobile phone in India in the year 2002 or in and around that. Only incoming, outgoing there. Simple Nokia, very heavy color and very heavy silver color and only incoming, outgoing with that. Now we got video calling facility. Google Meet, Zoom Meet, WebEx Meet. What is this? Improvement of technology from AGBL to mobile phone. Therefore, from this example, I want to make you understand that I want to convey one message to you all that getting patent is not difficult. If you are doing improvement in the machines, devices, composition, process, medicine, you can improvement in technology also, you can get the patent. AGBL got the patent, even Apple got the patent. X-ray machine got the patent, CT scan machine got, because improvement in the technology. So try to do the formulation improvement, machine, all. So these are the examples of patent and inventions. Many examples you can see. AI in medical diagnosis. AI system detecting breast cancer, TB, retinal disease. What is this? For algorithm, you can go for the copyright. As a medical device, you can go for the patent. Again, see, mRNA vaccines got the patent. Solar roof tiles. Solar panels were there, but somebody developed even tiles also that function as an solar panels. How it looks, you can go for the design. And technology, you can go for the patent. And name of the company, you can go for the trademark. So these are the examples are different. बहुत pollution हो रहा है दिल्ली में. How can I give the solution? So somebody had developed carbon capture technology, that machine that directly capture the carbon dioxide from the air. What is this? Invention or technology. So patent is given for the technology, which is product or process, novel, inventive, and capable of industrial application, and should not attack section 3 and 4 of the Patent Act. Now, let us see another kind of intellectual property called designs. मेरा आयरन बॉक्स है, आपका कैसा है देखिए, नया डिजाइन। आपके स्पेक्टिकल देखिए, मेरा स्पेक्टिकल नया डिजाइन। मेरी पेन, मेरा पानी पीने का जग इज like this design. You can see, and Milton name is trademark this and this and design. So my printer, my laptop, my stabilizer, my watch, simple. So anything which looks beautiful, that's an design. See, flash design, brush design, mobile, car, mere functional or technical feature of the article is not design. How it looks, that's in design. It should be appealable to eyes. Term is 10 years. You can extend for 5 years. Total 15 years term for the design. See, beautiful cup set, sofa set, spoon set, chair set, pen set, cooker set. These are the setup articles. This is a new machine we saw during the corona. See, all these are new designs. See, textile design, curtain design, bedsheet design, earrings, bangles, watches. All the designs are different. You can see. You can check your water bottles, office bag, wallet, your chairs. All the designs are different. So all the designs are different. You can see this and beautiful designs of the bag and all. I'll call you. I'm in lecture, sir. I'll call you. Okay. I'll call you. I'll call you. I'm in lecture. I'll call you. I'm in lecture now. So these are the different kind of designs. Since how long you are drinking Coca-Cola, Maaza, Sprite, but you never thought why Coca-Cola bottle design is like this, why Sprite bottle is like that. You never thought of that because all are having different designs. See, these are the different designs. Again, this design was developed on the student. Again, new design. Let us see another kind of intellectual property called semiconductor integrated circuit layout designs. Physics, electrical, electronics people are knowing what these circuits are. Earlier, we used to use China chips, Taiwan chips. Now, if you are able to develop original, novel layout of design of semiconductor, you can go for the register in the government of India. Office located Delhi, you can file online or offline. Term is 10 years. Let us see another kind of intellectual property called trademark or brand name. Visual symbol, which may be word, name, brand, numerical or combination of colors to indicate the source of the good, to distinguish from the others like Tata, Bata, Parleji, Good, Monaco. All these are different name which can address the company. Protect the innocent public from buying the goods of second-rate quality product. You can see if you're going to the mall to buy the Adidas shoe, more than 4,000 rupees is the price. But now if you go to the mall, roadside of Mumbai, Bindi Bazaar, VT side, 200. Why? They're changing spelling or markup that they're coming the second-rate quality product. To protect that, we should know the exact trademark of the company. R with a round is an registered trademark. TM means you applied for the registration term is 10 years. Let us see another kind of intellectual property called GI, geographical indication. Place name, user to identify source of origin, quality, reputation, or other kinds of products like Biapurchi Mirchi, Vaigauchi Halad, Draksha Nasik, Busal Banana, Tirupati Laddu, many got there, Itapalli Sagwan. These are the different kind of GI. Now, let us see another kind of intellectual property called copyright. What is copyright and how you are making the benefit out of that? Copyright is a bundle of right. It covers lot of things. It restricts unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, and software. The term is life of the author plus 60 years. Therefore, some songs you have to pay for that. Why? Royalty has to go to the person who has sung the song. While book, the royalty goes to the author because term is life of the author plus 60 years. We speak, Arey Bahubali is dubbed from Telugu to Hindi. What is the dubbing? Somebody is copying something out of that. There are many infringement of cases in the court. As you are not aware of that, you are not a lawyer, therefore you are not having much awareness about that. Many things are getting copied. That can be song, movie, pictures, drama, books, stories, many things. Therefore, many infringement cases are in the court. If you are writing books, novel, story, thesis, project, or poem, or we can say any literary work, you can go for the protection under section 2 of the Act. If you are going artistic work under section 2C of the Act, dramatic work under section 2H of the Act, musical 2P, sound recordings 2XX, cinematograph films 2F. So each kind of work is getting registered in the copyright. Therefore, we say bundle of rights. And you might are knowing who is having the ownership of. For example, if you're writing book or dramatic work, the author is having the right of that. For musical work, composer is having right for that. Artistic work, other than the photograph, artist who is drawing that. And photography, the person who is taking the photograph of that, not yourself. Cinematograph films or sound recording, producer. Literary, dramatic, musical, artistic, or work which to be computer generated, the person who causes the work to be created is the owner of that. And while filing the copyright, you can visit to the copyright.gov.in. You will get all the detailed information about that. Now, let us see another kind of intellectual property called trade secret. Some invention, data, information, if you don't want to publish or protect, you can keep a secret that is called trade secret. For example, I'm having idea of making Coca-Cola. Till today, since how long we are drinking, but they have kept secret that is called trade secret. Maza we cannot prepare in our kitchen. KFC recipe we cannot. That all are trade secret. You are eating pizza in normal hotel, homemade and the Domino's, which are in the taste and fluffy. Obviously Domino's because the process of making dough, we don't know, that's a trade secret. What ingredients they are adding, we don't know, that's trade secret. What is the composition of that dough, we don't know, that's again trade secret. Now, let us see another kind of intellectual property called protection of plant varieties and farmers' rights. For example, we know Patent Design Trademark Act 99, but it is a part of the IPR, but we have dealt separately. If you are developing new varieties, like Jaya, Pusa, Padma, Basmati rice, Kolam, Kalamosh, any kind of new varieties, food varieties, or fruit varieties, if the seeds are novel, uniform, stable, you can go for the registration in the government of India. Who can file? Breeders, farmers, university, and agriculture institutes can also file for that. Term is 15 years for annual crops, 18 years for the trees and vines. So you learned what is essential for the IPR. Ideas are essential for the filing the patent design trademark. And if you're writing the book, you can go for the copyright, then get the money out of that by selling the market, and it's an asset. You are navigating in understanding the copyright. Now you learned idea to IPR. Now let us see one example to make you understand. Can anyone tell me what this symbol is and what kind of IPR? You can put in the chat box. What is this symbol and which kind of IPR it is? It's an apple. It is a trademark. Overall design of the laptop they got, that's a design registration. Inside this laptop, we have a circuit, that's a circuit registration. Again, the website of the or the manual of the laptop, you can go for the copyright. So single product, they got patent for the technology. The distance between J.M. Patel College, Bandara to Nagpur is an output. Technology can go for the patent. So single product, but they got patent, design, trademark, copyright, and trade integrated circuit. Therefore, they are in the market. No one can copy the technology. No one can copy the design. No one can trademark. This is again power of intellectual property because you are creating your ideas, protecting that, which are essential for the IPR, and you are getting money out of that by selling in the market. The price of laptop of Apple is more than 1 lakh rupees. Mobile is 1 lakh. So you are getting money out of that. It's therefore it's an asset. I'll quote another example. Can anyone tell me? क्या है छोटी फिर बड़ी फिर छोटी फिर बड़ी? What is this? Which kind of IPR it is? It's a design. Coca-Cola in this style. What is this? It's a trademark. What is inside this bottle which is brown in color? Coca-Cola. The machine from which I am manufacturing the bottle is an technology. I can get patent for that. mark. I protected all with an example. I am the owner in the only market I am getting benefit out of that. No one can copy. This again, power of intellectual property. So you learned how to protect your technology, ideas, books, or if you want to keep secret, you can keep secret also. Now, let us see how to file your patent application in the Government of India. Who can file? Any person can file, startup, MSME, alone, individual, no age bar limit or education limit to file the patent application. Offline or online, you can file. Your jurisdiction is Mumbai, you can file in Mumbai. If online filing, you should have e-signature or digital. Offline filing, no need of signature, but you have to pay the more fees. Form required are Form 1, Form 2, Form 3 for foreign filing, Form 5 to add your friend's name, Form 18 for request for examination. With this, if you are filing online, pay the fees online. If offline, pay the fees offline. Form 9 for early publication is optional. Form 26, if you are going to attorney, is required for that. Fees is given in the website, 1,600 for natural person, 8,000 for others, up to 30 pages. Per page, per claim, more than 10 is increased. Please visit our website www.geo.in, www.ipindia.geo.in. You'll come to know all details about the intellectual property rights and their fees and filing also. So examination fees is 4,000 for natural person, 20,000 for the others, means company or institute. If you're government institute, you are hanging. If you know more website, like if you want to file the patent, please go here. Designs, trademark, GI, and copyright. If you want to file online, comprehensive e-filing, click here, then e-signature or digital, patent, design, trademark. Whichever you want to file, go with that. If you want to search whether idea is new or go to the public search, put mosquito repellent composition, detergent composition, process of making tea, process of making something, whatever done, a fermenter or electronic device, whatever you want to put in the public search, or you can go to the Google patent, or you can go to the EVSO patent, or EPO patent, or WIPO patent. You can search in free database this all. If you are not happy with this, you can go to the pay database also and you can pay the fees. If you're able to get new idea, then you can search. If really new, go for the patent filing. And here, if you want to file the copyright, please click here. No need of any kind of signature like digital or e. Only you have to log in, create your ID password, keep your book or copyright in the PDF form, whatever you want to file, fill the form 14, upload the document, pay the fees 500 as per the requirement, and 30 days waiting period for that. Any objection, you are getting the letter. Otherwise, it will be accepted. So these all about the patent, design, trademark, and copyright. With this, I put in full stop to my presentation. Any questions will take for the 10 minutes. Thank you.
Sir, good morning. This is Dr. Bhaumik.
Yeah.
Sir, a very common question because I'm principal of an arts, commerce, science college. Sir, science people, I am from science background only. Science people, they have a very clear idea about the patent and all. But these, in new generation, the arts people, they are a bit, worried and a bit puzzled, and they don't know how to go about it. How to choose the topic, on what topic.
Yes, you are right. So you want to know what arts people can file the patent application, isn't it? What do you want to know from me? Bhaumik sir? Hello? I'm audible to you? Hello? Hello?
Yes, sir.
I'm audible to you? Hello?
Yes,
Hello?
sir. Yes, sir. You're audible.
Yeah. So
You're
Bhaumik
audible,
sir,
sir.
Are you there? See, here getting idea in the mind is not required art science fellow. Anyone can get the ideas. For example, one of the student from Nagpur has got idea to develop a device which can indicate that you are getting the heart attack. So it's not like that. One of the South Indian fellow is a 14-year-old. He has developed a composition to keep the banana leaf as an alive green for 6 months. It's in composition. So it's not required that getting ideas, arts or science. If you are having any new idea, you can file the patent. But for subject what if you're saying for arts, commerce faculty, if you're developing business method, business system, if method, you can go for the system, you can go for the patent. So depend upon what kind of idea you are. One of the Ranganathan person from South India developed scooter for tree climbing. It's not an inventor. Many Vedas from uneducated, they are giving Ayurvedic medicine. They are not science background. They are not botanists. They are not anthropologists or not nothing. So even though they are getting the Ayurvedic medicine, so it is not required. Remove your mentality or art science. So anyone can file the patent application. Bombay sir, you are there? Yes, it's not required. Anyone can get the idea. If idea is new, you can go for the patent. In things of your political science or geography book means you can write the book, you can go for the copyright. But yeah, such any idea, anyone can get at any age. So many example you can check in the Google. Many youngest people got the patents. So anyone can develop technology. There is no age bar limit or education limit to file also. So simple like tree climbing machine, somebody has invented. Nimbore, we can see the one of name. You can put Ramya Jose, you can put in the Google. She has developed an washing machine without electric power by running herself. So you can check Adinath has developed some machine to play the game. So many inventions are there which are done by the youngest students, even they are not in the college level. So don't remove from your mind that arts faculty are not having any ideas. If it is new, novel, technology you can go for the patent. Other you can go for the writing books, you can go for the copyright, make the benefit of that. Thank you.
Um,
Yes, Bomik sir, it's okay. Any other question?
if anybody wants to ask question,
ठीक है, आगे बढ़ाइए। इनवाइट भौमिक
जी,
सर, क्योंकि सर को
thank you so
दूसरा
much,
टॉक
sir.
भी है, सूर्यवंशी सर को टॉक है।
No problem. So question we can solve 1 or 2 minutes, no problem at all. I am Manish Baramati online. That's also.
Um, I wish to convey my genuine gratitude for your significant contribution to our event on intellectual property rights, sir. Your presentation was very informative, interesting, and insightful. I'm very sure it has enhanced our participants' comprehension of the topic, sir. Your proficiency and experience in the field of intellectual property rights have significantly benefited all of us, sir. Now let's move to the last part of the segment of this program, that is vote of thanks. On behalf of all four colleges, I invite Honorable Dr. D.S. Pomik sir, Principal, College of Multidisciplinary Studies, Nagpur, to propose vote of thanks. Bhaumik sir, you are muted. Bhaumik sir, you are mute. Sir, please unmute yourself. Bhaumik sir, you are still mute. Please unmute yourself. You are not audible, sir. Sir, you are still not audible.
Bhaumik sir.
Bhaumik sir, you are not audible, sir.
Bhaumik sir, आप सुनाई नहीं दे रहा, आपका अनम्यूट करो। नहीं, आवाज बिल्कुल ही नहीं आ रहा।
आपण डायल केले
Hello.
Perfect.
Now you are audible, sir.
Perfect.
Okay, fine. Good morning, everyone. It's my privilege to propose a vote of thanks on the behalf of the organizers. I extend my heartfelt gratitude to our esteemed guest speaker, Dr. Bharat Shurivanshi, for taking his time out of his busiest schedule and enlightening us. Thank you for providing such a clear, comprehensive, and insightful understanding of the intellectual property assets. Your expertise has truly inspired all of us. Your very down to earth examples, sir, have really elevated the impactfulness of the workshop. I am very sure that all participants might have got an opportunity to understand and utmost clarity about today's topic. Dr. Survanshi sir, let me tell you that in recent time, your delivery is one of the finest delivery I have heard on this IPR. And I congratulate you for that, sir, for your nicest delivery. A special thanks to all honorable patrons. I would like to express my deep gratitude to all principals, Dr. Pradeep Meshram, Dr. Akhilesh Peshwe, Dr. Priya Vanjari, Dr. Daneshwar Knight, for their absolute constant guidance, support, and encouragement in organizing the event. A special thank to Dr. Karthik Panikar, all IQAC coordinators, and innovation and incubation cell coordinators for their tireless efforts in bringing this program really to great success. I also thank our technical team, administrative staff, special thank to volunteers who have worked behind the scenes. Thank to all the participants, students, faculties who have actively participated participated in this seminar, and I have not heard anyone asking questions on that. But anyway, it's okay. Uh, uh, I think this workshop has been a great success. I sign off with some motivating facts. Let me tell you, all audience, that in 2025, India has achieved sixth rank globally in patent filing. Let me tell you, on 2014 it was around 42,000. Now this 2025 we have crossed 1 lakh. So it is a great achievement for us, and to all those who have participated. Thank you so much. Thank you. I sign off.
Thank
Over
you.
to you, Patilman.
Yeah, thank you so much, sir. It gives me immense pleasure and to announce that our program has come to a successful conclusion. I hope that everyone has found this event very informative, engaging, and productive regarding the IPR. Thank you so much, all of you, once again. I request all the participants to please fill the feedback form, which the link will be shared soon in the group. I request all of you to please fill that form. Thank you.